I'm missing a page, but never mind, I will get on to that. Quite a few pages are. Sorry, it's not on the screen, but just let me run through a couple of more cases. In Lee against Chauvin Guild of Great Britain, Lord Denning had this to say as to when the courts will intervene. It says, questionnaire, to what extent is the court likely to intervene in matters involving domestic tribunal of a social club, as in the present case, as opposed to tribunals sitting in judgment over matters of the trade or profession. Now that was way back in 1952. The question then, of course, is whether the same sentiments apply to today. And the question that Lord Denning posed was that to what extent will the court examine the decisions of domestic tribunals on points of law? In the case of Amateur Athletics Association against Harun bin Mundir, it's a Singapore Court of Appeal case, 1994. There the court held the jurisdiction of the court in reviewing the decisions of domestic tribunals is clearly of a limited nature. The decision of a tribunal cannot be attacked on the ground that is against the weight of evidence. Now remember earlier on, I did say to you that the jurisdiction of the courts here is not to act as an appeal court of what has been decided by a tribunal, but merely to check and review the procedure, whether there's a procedural fairness in arriving at a conclusion. And in another case, in Chong Kok Lim against Yong Su Hian by Justice Hashim Yopsani as it then was, I think he said this in a very short, and I'll quote this very shortly, it encapsulates the position as we know it today. He said, I'm well aware of the established approach or principles adopted by the courts dealing with private clubs or associations as successfully put by Scotland Lord Justice in Young against Ladies Imperial Club Limited. It has been made clearly understood that the court is not a court of appeal on decisions of committees of clubs and associations, provided, of course, the committees are properly constituted and properly summoned. But I was wanting to come to this case, and this is what Justice Abdul Qadir J, as it then was said, and this is quite interesting. Although in the past courts were inclined to say that proceedings of domestic tribunals should not be lightly interfered with, there has been a decided change in approach since. And of course, you know, Justice Abdul Qadir was a very outspoken revolutionary judge, and he said the courts will now always interfere when disciplinary action is taken beyond jurisdiction by any domestic tribunal. And I think this particular quote still stands till today. And once this matter of a jurisdiction, issue of jurisdiction arises, the courts will always invariably interfere. I'm so sorry, I don't know why so many of the pages are a little mixed up there. Sorry, I had mentioned Lee and Chauvin. It was the long quote. We'll go through that. That's a Singapore case, Chong Kok Lim. And this is what Abdul Qadir has said. Okay. In Florence against Bales against Dr. Ng Jit Leong, 1985, by Justice Ajib Singh. And there's a question of whether you can have the ouster clause, whether the club rules will oust the jurisdiction of the court. And this is what the judge said. Jurisdiction of the court to determine questions of law cannot be ousted by any club rule. And that in matters of law, the court is the sole arbiter. So I think this is an important point that when lawyers are putting your agreements together, drafting constitutions for clubs, please bear in mind, you cannot oust the court's jurisdiction by consent. In fact, in the next line, he says, this is, judge says, in such a case, the court is not only not incompetent, double negative, not only not incompetent to intervene, but it's the only forum to which a aggrieved member may look for redress. Very quickly, in the case of Kamarudin, a very recent case, 2011, this is what D.C. Singh JC, as it was said, in a case of representation, whether all members must be peculiarly and personally affected as a whole, or whether some of the members who are affected can bring an action to court. Again, this was an Order 15 case, whether the plaintiff had the capacity to bring the action. This is a case concerning the Malaysian Racing Association. They had the rules of racing, I believe it's Rule 230, which had this requirement to say that owners or trainers of horses with the MRA, they should not allow the average number of horses to be trained to be fewer than 20 horses per month. So this question of how do you monitor this and how do you comply with this rule. But importantly, in this case, Justice Lee held that the members need not be peculiarly and personally affected as a whole before an action can be brought, so long as all members are potentially and prospectively affected, and only some are peculiarly and personally affected, will be in a sufficient justification to activate an action. But this is about the rule about the 20 horses. How am I for time? Am I all right? Yes? Okay. Okay, another very interesting case, a very recent one. The Singapore Professional Golfers Association against Chen Weng. It was a tort case, passing off, whether there was real and tangible risk of substantial damage to the appellant's goodwill. And you know, as in Singapore, as in many other golfing associations, it's known as the Singapore Professional Golfers Association, shortened for to SPGA. Now, the first respondent, he had been suspended from a golf tournament, which was not sanctioned, and he, together with his son, the second respondent, formed the third respondent and named it the Singapore Senior PGA Limited Partnership. And the initials were SSPGA. So, of course, the plaintiffs were pretty upset. They says, look, you're going to cause confusion, and so on. And the court held the claimant had to show that there was goodwill attached in the first place, which they successfully managed to do, and that tort of passing off could and did extend to non-commercial organizations. So that's important, right? So it applied to clubs and associations, not just to a business company. The claimant had to show his name or brand was distinctive. The appellant's name had acquired a secondary meaning by virtue of it clearly being identified with the appellant, and that there was a strong similarity, and the usage of the names and initials would cause loss to the plaintiff and potentially loss of subscriptions and income. Right, a very recent case. This one, a case that my panel decided, and I wrote this decision actually. Masuma Sports against Majlis Sukan Negara, report of 2014 in the LNS. It's a very interesting case because, you know, if you look at the jerseys which are worn by Malaysian athletes, you'll see the stripes, the tiger stripes. Yeah? Now, the question is, who came up with this idea to have the stripes, and who had the first user, and who enjoyed the trademark? Now, in this case, Masuma Sports had been appointed by the Ministry of Sports through the Majlis to manufacture and produce garments, sporting garments for athletes representing Malaysia, both in domestic events and international events. So Masuma Sports got this contract. They actually went on to manufacture the garments, and they claimed first user. It's very interesting because the design was given by the ministry. Here's a contractor who made use of it as a first user, and by virtue of that went on to register a trademark under the Trademark Act. Of course, the ministry and government was very upset, and they took an action against the company. So the Majlis, being a Greek party, filed a suit for tort of passing off, and the appellant, Musuma, had the audacity to claim in turn counterclaim for infringement and passing off of his trademark. So it's a very interesting tussle going on in this case. And importantly, the appellant did not dispute that the Majlis, the respondent, was the lawful owner of the design, but only that it claimed to be the lawful holder of the trademark by being the first user of the mark. Right? So we held that on the facts that apart from the design that respondent was the owner of the design and was in fact the first user. In fact, it merely appointed the appellant as a paid contract supplier. We said a more liberal interpretation of the phrase "in the course of trade" was to be applied, and that the respondent had enjoyed sufficient goodwill. We also went on to say then that the appellant had wrongfully registered the design as his trademark and was filed in bad faith because the appellant's mark was identical to the mark of the Sports Council, and therefore we allowed the claim to expunge, the respondent's claim to expunge the appellant's trademark from the register. Now all these cases, of course, ladies and gentlemen, deal with litigation. Yeah, and of course you will know that that will be the last resort. But what about ADR in dispute resolution in sports law? I don't think I will spend too much talking about arbitration in this instance. I think that was the topic largely dealt with by Dato Sundra at the last conference. But I want to say a little more about mediation. Now, as we do know that mediation, we now have the Mediation Act, and this is now becoming an in thing as far as dispute resolution is concerned. The Malaysian Bar Council, of course, has the MMC, Malaysian Mediation Centre, which comes under the auspices of the Malaysian Bar Council. And anyone undergoing a course can be accredited with the centre, and then you can, of course, go on to be a mediator. But you really, like being an arbitrator, you do not need to be qualified as such. You don't need to have any particular or special qualifications to be an arbitrator or to be a mediator. And I think in mediation, what it really requires is a good sense of fair play and a lot of common sense. But importantly, I think what has developed very recently in mediation is that we are talking about court-annexed mediation or court-led mediation. You will always have the cases of private mediation and so on. But I think the advantage of a court-annexed mediation are many. One is that you don't have to pay for it. It's free. Now, if you have mediation by private mediators, I think there's a daily charge, there's an initial payment and so on. But in court, anyone can ask for mediation. In fact, in Kuala Lumpur, in Jalan Duta Court Complex, there is a mediation center with facilities for meetings and discussions and so on. I wonder how many of you have actually visited or used the facilities at the court complex. It's very conducive to negotiations, very conducive to settling any disputes. But importantly is that when the case comes up in the High Court, at case management, the registrar will ask you, you meaning counsel for either parties, whether you want to have mediation. All you have to do is to indicate, and the judge will be more than happy to have mediation. It need not necessarily be at the start of a case. I've had cases mediated successfully during a trial or even towards the end before judgment is delivered. The processes, I think, is quite familiar to you. But I think what is really important, my personal experience is that if you want to have successful mediation, lawyers must take a back seat. The moment you have lawyers speaking up for everything that the parties want to say, you're going to be far from a resolution. So the trick is, we have the lawyers come in together with the parties at the start of the mediation. What I generally do, very quickly, is that I'll ask the counsel for the plaintiff to state his case very briefly, in a few words, what it's all about, in the presence of everybody else. Then the defense counsel will do the same, summarize the case in the presence of everybody else, and then I will ask them to leave the room, whether it's the chambers or the center and the court. And you will hear both parties when they are in each other's presence. But as I say, it's very safe, because in the chambers, the table is fairly wide. You have the plaintiff sitting on one side and the defendants on the other side. Even if they get up and stretch across the table, he will not be able to reach the other guy. So it's very safe. And the judge, of course, is protected by another table. So it's all, actually it's very conducive. And you'll find that parties, when they do appear in court for mediation, they know, parties know that, look, this is the last resort. They're coming to court. And somehow you'll find that there's always this willingness to want to settle the case. And all you have to do as a mediator is to push them along, and encourage them and say, look, it's better to have a successful settlement than to have a suit that you go through and then you lose in terms of time, costs, legal fees, and so on. And as you also do know, that in mediation, it's so important that you don't burn all the bridges. You try to preserve some of them so that relationships can continue. Before I conclude, I just wish to say that, as far as mediation is concerned, you will find that domestic issues, matrimonial issues, are in fact easier to mediate. I think in Kuala Lumpur, the record is about 70% success rate. For the very few family matters that I have mediated, they've all been successful. And I think it's simply this, that by the time they come to court, the parties know that really there's not much point in fighting further. They just want to resolve it as best as they can. So if you give them the platform and say, look, this is how the whole process works, and I think the important thing is that they are hearing it from a third party, an independent third party, not just from your own lawyer, and of course you will not listen to what the other lawyer says. So when an independent third party presents the case on a neutral platform, I think that does the trick. Just one more example of what mediation can do, and very successfully, and big savings of time and court resources and so on. Was I had a mediation in the Court of Appeal not so long ago, and we, in the course, or rather at the start of the hearing, we asked the parties whether they wanted to consider mediation, even though the case was ready for hearing on appeal, simply because this was a dispute between mother and a son on one side and a daughter on the other. And they said yes, and we went on for mediation. It took an afternoon, and then the parties said they will go back and think about it. And at the end of that afternoon, I said to myself, well, it's something which I always say, don't postpone any mediation, because if you do it halfway and parties go back, you are bound to be, parties are bound to change their minds and say no the next day. But anyhow, this one of the parties asked for it, and they seemed quite genuine. And the next day, they came back and with further discussions, and they actually settled the case. It's all a question about the sister working for the brother, not being paid, and not after being promised about ABC of whatever was to be done. The important point, of course, and I think this has nothing to do with law, but from the social, personal aspect of things, and I think this is what is so rewarding when it comes to resolution of a dispute, and that is, here is the daughter. The daughter was so estranged from the mother because of what was going on between her and the brother, that they were not able to see each other for years, even over New Year occasions and so on. But when the resolution was achieved, the daughter literally went up to the mother without any prompting, went up to the mother, gives her a big hug, touches her feet and says, look, let's forget and forgive everything that has happened and let's get on with life. I tell you, ladies and gentlemen, that is the best reward you can ever have to any dispute resolution. Thank you.